Welcome to this explainer. Today, we're diving into a historical moment where a legal system literally crumbled under intense political pressure. We're talking about a true trial by political farce. You know, when we think of Bhagat Singh, we usually think of his revolutionary zeal, right? But this event is just as important for its massive legal and constitutional implications. We're going to break down exactly how a desperate colonial regime engineered a trial that systematically threw out the very foundations of its own justice system.
Okay, let's kick things off with a pretty crucial definition. Professor Otto Kurtheimer describes a political trial as a proceeding conducted, well, not really to find the objective truth, but with a view to evicting a foe from the political scene. Basically, a regime stages a trial to incriminate an enemy's public behavior. It's like wrapping a political elimination in the disguise of legal procedure. Keep this idea in the back of your mind as we look at exactly what the government did here. Now, our whole exploration today is grounded in A.G. Noorani's meticulously researched book, The Trial of Bhagat Singh, Politics of Justice. While history rightly remembers Bhagat Singh's incredible courage, our source material takes a really impartial look at the darker, structural maneuvers the British colonial government used against him. Noorani essentially argues that this was a textbook case of abusing the judicial process for purely political ends.
Section 1. Defining the political crime. Let's look at the inciting incidents that really sent the regime into a panic and set the stage for this whole trial.
The dominoes fell incredibly fast. It all started in December 1928, when Bhagat Singh and his comrades assassinated British police officer John P. Saunders in Lahore. Now, actually, this was a case of mistaken identity. They had meant to target the officer responsible for the death of nationalist leader Lala Lajpat Rai. Fast forward just a few months to April 1929, and Bhagat Singh and Batukeshwar Dutt threw bombs into the Central Legislative Assembly in Delhi. By May 1929, the magisterial trials had already kicked off. So here's the absolutely crucial point. After throwing those bombs in the assembly, Bhagat Singh and Dutt literally made no effort to hide or escape. No resisting arrest, nothing. Why? Because they willingly surrendered with a very specific strategy in mind. They wanted to use the ensuing trial as a massive, highly visible political forum to broadcast the revolutionary cause to the entire world. They knew, as they said, that the sacrifice was inevitable, but they fully intended to turn the regime's own legal system into a stage for their defiance.
Section 2. The hunger strike weapon. Once they were locked up, the prisoners definitely didn't just sit quietly waiting for a verdict. Their primary strategy was actually a distinctly Gandhian weapon, the hunger strike. Bhagat Singh and his fellow accused demanded to be recognized not as common criminals, but as political prisoners. They wanted specific rights, things like access to newspapers, better food, and the ability to just consult with each other. The authorities' response? Brutal, systematic violence. The prisoners endured these horrifying forced feedings, where multiple guards would literally pin them to the floor just to shove rubber tubes down their throats. It was a bleak, harrowing ordeal. But despite the severe violence, these prisoners absolutely held their ground.
And you know, this perfectly illustrates the immense impact their strike was having way outside the prison walls. Speaking in the Central Legislative Assembly, Muhammad Ali Jinnah delivered this incredibly powerful defense of the prisoners' motives. He pointed out that these were not ordinary criminals. They were individuals moved by their souls and a deep belief in the justice of their cause. Jinnah's impassioned speech stood in really sharp contrast to the government's rigid, punitive stance, and it totally exposed the political nature of this conflict to the entire country.
All of this brings us to a massive legal dilemma. Think about it. The state is trying to run a formal trial, but the defendants are inside shouting slogans like "Inqilab Zindabad," demanding political rights, and physically deteriorating from their hunger strikes. This tension forces us to ask a big question. What on earth does a government do when its normal legal machinery is completely paralyzed by the very people it's trying to prosecute?
Section 3. The magisterial farce. We actually get the answer to that question during the initial hearings before the special magistrate in Lahore, which is where the facade of an impartial justice system just began to completely crumble.
Court decorum just entirely broke down. In October 1929, the prisoners were forcibly handcuffed, brutally beaten by police, and dragged into the courtroom, gasping and covered in dust. And the magistrate? He simply watched helplessly, just taking orders from the prosecution. Instead of backing down, the prisoners defiantly sang songs like "India will never remain a house of slaves." Bhagat Singh openly called out the proceedings as a total farce, declaring that the British government was acting vindictively. This completely stripped away any illusion of a fair trial, exposing it for what it truly was, a trial by political farce.
Section 4. Trial by tribunal.
Realizing they couldn't break the prisoners or smoothly convict them under normal laws, the regime simply decided to change the rules of the game entirely.
Now, what's really interesting about this is the stark contrast. On one side, you have the standard British judicial process, rights that were theoretically guaranteed. But on the other side, you have the draconian rules of the newly created special tribunal. The government just stripped away the right to appeal to the High Court. They removed the requirement for High Court confirmation of death sentences. They set an arbitrary 6-month term for the tribunal. And crucially, this is wild, they allowed the trial to proceed entirely in the absence of the accused.
So how did they even achieve this? Through raw executive power. On May 1, 1930, Viceroy Lord Irwin promulgated an ordinance to establish this special tribunal. He bypassed the Central Assembly legislature entirely. Why? Well, because he knew for a fact he lacked the majority to pass such an extreme and legally dubious measure. This was a parallel emergency power used for one reason only, to ensure a swift conviction while completely sidestepping every normal legislative check and balance.
Bhagat Singh's reaction to this maneuver was incredibly insightful. He didn't see the tribunal as a defeat at all. Actually, he viewed its creation as a massive political victory. By abandoning their own legal standards and handpicking a tribunal to try them in absentia, the government proved Bhagat Singh's exact point. They had finally shown their true colors, proving to the world that their authority was based purely on force and arbitrary power, not on any genuine legal foundation or justice.
Section 5. The Privy Council Appeal. Despite the glaring biases of the tribunal in Lahore, the defense made one final attempt to challenge the legality of this whole process, taking the fight all the way to London.
Standing before the highest court of appeal, the Privy Council, defense counsel D.N. Pritt laid out an absolutely brilliant legal argument. He meticulously broke down how the ordinance systematically stripped away fundamental rights. He argued that the accused were deprived of the right to know the case against them, deprived of a jury, and deprived of an appeal. But most importantly, he argued that the Viceroy's ordinance wasn't true legislation at all. It was a gross abuse of arbitrary executive power, designed solely to circumvent the law for political convenience. So let's see how this builds to the final tragedy. The Privy Council, despite all these massive constitutional overreaches pointed out by the defense, effectively rubber-stamped the convictions. They upheld the validity of the Viceroy's ordinance, and by doing so they allowed the monstrous illegalities of the trial to just pass muster. This officially secured the political eviction that the colonial regime had engineered from the very beginning, and the death sentences were confirmed. This brings us to a final, really provocative thought directly from our source material. When we look back at the stripping of rights, the brutal police violence right in the courtroom, and the arbitrary changing of laws via executive ordinance, we really have to wonder, was the trial of Bhagat Singh ever a genuine pursuit of justice? Or, as the author suggests, was it a forensic Jallianwala Bagh, a massacre not of bodies in a public square, but of legal rights and fundamental justice inside a courtroom? It's a powerful question that really challenges how we understand legal systems operating under political weight, reminding us of the enduring dangers of a trial by political